Hey guys, welcome back to the channel where we break down complex legal topics and make them easy to understand. Today we're discussing a serious crime under Singapore law, digital penetration. What does it mean legally and what are the penalties involved? Now, when we talk about digital penetration, we are not referring to cyber hacking or internet fraud. In legal terms, digital refers to the use of fingers or other objects in the context of a sexual assault. Section 3762 of the Penal Code criminalizes this specific form of sexual penetration. Section 3762 covers sexual penetration by a part of the body other than the genitalia or by any object. In simple terms, if someone uses fingers or any object to penetrate another person without consent, they can be charged under this section. The law is designed to cover acts of sexual penetration that don't involve traditional intercourse but still involve serious violations of personal integrity. In Singapore, this crime is treated just as seriously as other forms of sexual assault. Now, what are the penalties? Under Section 3762, if found guilty, the offender faces imprisonment of up to 20 years. In addition to that, the offender is also liable for caning or a fine. That's right, serious consequences for a serious crime. But there's more. If the victim is under 14 years of age, the penalties can even be more severe. The law takes the protection of minors very seriously in Singapore, as it should. Now, this is where it gets a little tricky. People sometimes ask, does digital penetration include, say, fisting? Well, the law doesn't specify, but that's probably one of the biggest legal grey areas. So in all seriousness, though, whether it's fingers, objects, or other forms of non-genital penetration, that means you don't use your cock. If it's non-consensual, it's a crime under Singapore law. The Singapore Court of Appeal, in the case of Prem Nair, set out the sentencing framework for digital penetration. The accused in this case was convicted of one charge of rape under Section 3751A of the Penal Code and one charge of sexual assault by penetration under Section 3762A for penetrating the victim's vagina with his finger. The incident occurred after a night of drinking at the Warehouse Club on Sentosa Beach in May 2012. The victim alleged that she was too intoxicated to consent to the sexual acts, while the accused argued that the sexual activity was consensual. The accused argued that the victim consented to the sexual acts, pointing to her friendly behavior earlier in the evening. However, the court found that her behavior early in the night did not indicate consent to sexual activity on the beach, particularly as she was heavily intoxicated and drunk by the time of the incident. The Court of Appeal stated that there is a difference between penal penetration, that means using your cock, and digital penetration, that means using your fingers, because penal penetration carries the risk of unwanted pregnancy and of transmitting a sexually transmitted disease which would have far-reaching consequences for the victim. The knowledge that she could be at risk of becoming pregnant or contracting a sexually transmitted disease would inflict an extra level of trauma on the victim. Secondly, the Court of Appeal stated that penal penetration is a more intimate act than fingering. The abuse of such an act therefore represents a greater degree of intrusion into the sexual autonomy of the victim. Also, an offender derives more gratification from penal penetration than digital penetration. There is therefore a greater degree of exploitation by the offender. The Court of Appeal recognized that as a matter of case law, our courts have always said that rape is generally regarded as the most grave of all the sexual offences. The Court of Appeal held that there is an intelligible difference in terms of severity between rape and fingering, and formulated a new sentencing framework for this offence. The first are Band 1 cases, where an accused can face 7 to 10 years imprisonment and 4 strokes of the cane. Then there are Band 2 cases, where the accused can face 10 to 15 years imprisonment and 8 strokes of the cane. Then there are Band 3 cases, where the accused can face 15 to 20 years imprisonment and up to 12 strokes of the cane. The Court of Appeal referred to the case of public prosecutor and Koh Nai Hock and considered it as a Band 1 case. The accused in Koh Nai Hock held himself out as an alternative medicine practitioner and penetrated the victim's ass and vagina on the pretext of treating her for infertility. He faced 14 charges under Section 3762 of the Penal Code, 7 for fingering her in her vagina and 7 for fingering her in the ass. The district judge gave him a total sentence of 7 years imprisonment. The Court of Appeal then classified public prosecutor and GBA as a Band 2 case. In GBA, there were two offence-specific aggravating factors. First, the victim was vulnerable as she had passed out from drinking alcohol and was unconscious while the sexual assault took place. Second, the offence was premeditated. On appeal, he was sentenced to 8 years imprisonment and 6 strokes of the cane. For an example of a Band 3 case, the Court of Appeal referred to Public Prosecutor and Azwar bin Ahmad. In that case, the assaults were premeditated. He drugged them with Dormicum, a date rape drug which caused the victims to lose consciousness. Secondly, the victims were also vulnerable as they were unconscious when he committed the assaults. The High Court sentenced him to 12 years and 6 months imprisonment and 12 strokes of the cane for each charge. So as you can see from these cases and the sentencing bands, fingering someone without their consent is a very serious offence, which is just one level below rape. I hope you find this information helpful and will think twice if you ever have the urge to finger someone. Thank you for watching and I'll see you in the next video.